Afternoon and welcome. Good afternoon. Welcome to the CondoWise Learning Series. My name is Patricia Aaliyah. I'm from the law firm of Aaliyah Associates, and we are condominium lawyers practicing condominium law here in Ontario. So today, session number 17 is about shared facilities, an exciting topic, needless to say, and we've broken it down into two parts. Part one is going to be about the anatomy of playing nicely in the sandbox. Now, that's something we hear about all the time. We should play nicely in the sandbox. But the question is, are we empowered to play nicely in the sandbox? Shared facilities is an interesting idea. Why not just one condominium? Financing, market interest, retention of commercial interests such as parking, commercial spaces in the community. These are all things that drive the creation of shared facilities. So there's more than one agenda at play. There are many motivations for creating these complex structures, which are very much like a sandbox where everyone needs to play nicely. Today, we're going to explore the anatomy of playing nicely by examining the anatomy within the anatomy. Next slide, please. This is not legal advice, and so we would recommend strongly that you ensure that you speak to your condominium lawyers about how to approach shared facilities ideas and issues. So our speakers today are Julia White, Ashley Winberg, and Shannon Penny. Without further ado, we're going to go right to Shannon to talk about the pandemic and give us an update.
Perfect. Thank you very much, Patricia. Hi. Okay, so last month, Ontario released its plan to follow a cautious and phased approach to lifting public health and workplace safety measures if health indicators continue to remain stable and improve. And with key public health and health system indicators continuing to improve, the government announced that the province would move into the next step of its COVID reopening plan on February 17th, and that the proof of vaccination requirements will lift on March 1st. So as of today, almost 90% of the eligible population in Ontario have received their first dose of the vaccine. Almost 85% have received their second dose, and 47% of all people in Ontario are now fully vaccinated with a third dose. So what changes came into effect on February 17th? So social gathering limits were increased to 50 people indoors and 100 people outdoors, and organized public events were increased to 50 people indoors, and there were no limits outdoors. Currently, the regulation does not define social gatherings or organized public events and does not provide us with any indication as to what the difference between the two is. These capacity limits do apply even if the gathering or event is held in a private dwelling or a condominium building. So owners' meetings can now be held face-to-face indoors, providing that they do comply with those capacity limits. However, it is important to remember, while the province is increasing its gathering limits, not everyone is quite ready to gather in a meeting room. So for the time being, condominiums may want to consider continuing to hold all their meetings virtually. So face masks are still required in all interior common elements, with the usual exceptions are related to age, health, and disability. Premier Ford advised that he will be making a decision by mid-March on whether to lift mask mandates in Ontario, and that his decision will be based on the advice of the province's top doctor. Until such time that an announcement is made, condominiums must continue to enforce the wearing of masks on all interior common elements. So indoor sports and recreational fitness amenities will no longer be limited to operate at a 50% capacity. However, users should continue to wear a mask unless they are exercising, and condominiums are responsible to clean and disinfect any equipment that is available to its users. This should be done as frequently as is necessary to maintain a sanitary condition. So Premier Ford announced the province's proof of vaccination requirements will be lifted on March 1st at all non-essential businesses. But with this being said, condominiums that have adopted a vaccination policy, they are able to continue to enforce them beyond this date, as the government did advise that businesses and other settings have the freedom to choose whether or not to continue to require proof of vaccination. So throughout the pandemic, isolation requirements have changed. So currently, if you have symptoms of COVID-19, you must isolate for 5 days if you are fully vaccinated or under the age of 12. You can end isolation after 5 days only if you have no fever and your other symptoms have been improving for at least 24 hours. If you are not fully vaccinated, you must isolate for 10 days. Everyone in the same household must also isolate for the same duration unless they have previously tested positive in the last 90 days and do not have any symptoms of COVID-19. In the event you are exposed to someone from another household who has symptoms, if you are fully vaccinated and currently have no symptoms, you must self-monitor for 10 days after exposure. If you are not fully vaccinated, you must isolate for 10 days after exposure, regardless of whether you have symptoms or not. If you have tested positive in the last 90 days and have been exposed again, you do not need to isolate as long as you do not have symptoms, but you must self-monitor for any symptoms for 10 days from the last exposure. You can go to work, but if you develop any symptoms of COVID, you then need to isolate for 5 days. Thank you, and I will pass you back over to Patricia.
Thanks very much, Shannon. I really appreciate you keeping us on top of how this evolves, because it is a moving thing, and that we will just keep you posted. We've come a long way, and it's interesting to see how Omicron has even changed the thresholds around these policies. So the next thing up is a poll. We wanted to understand if you're a director, property manager, or owner, and do you have a shared facilities agreement? And do you think that shared facilities agreements are useful or inevitable? Okay. With that poll, that would be great. Okay, so we've got property managers with us today. That seem to be the majority, which is great, but we've got a little bit of every category. And in terms of, okay, you all have shared facilities agreement, which is, I guess, why you're here. And we're evenly split, useful, inevitable, or both. So we're going to cover all of these points. Thanks for that, Justine. And if we could go to the next slide. So I'm going to turn you over to Julia, who has worked on, in her short career, quite a few different shared facilities agreements throughout the province and has seen it from different perspectives. So Julia, why don't you take us through a little bit of the anatomy of shared facilities?
Sure, thanks, Patricia. So first we're going to deal with what are shared facilities agreements. So shared agreements come with a variety of names. Shared facilities agreement, cost sharing agreement, reciprocal agreement, easement agreement, roadway agreement, and there's a few others. The purpose of each agreement is to define and set out the obligations, boundaries, and governance, including costs, for areas that are to be used or shared by multiple parties. For the most part, the agreements govern according to their name. So for example, a cost sharing agreement sets out which costs are to be shared by the parties and how this is to be done. Shared facilities agreements or reciprocal agreements establish the terms of the relationship between the parties and set out how decisions are to be made, what is shared, and who is to pay for what. So why do we want them? Shared agreements are necessary or desirable where two or more parties share property or components, or where there are easements granted between them. We don't want to rely on parties to just get along and share costs and share assets. This would be like leaving kids in the sandbox together, asking them to share toys and play nicely without any rules or supervision. The relationship needs to be set out in a written agreement that is binding on the parties and where there's legal recourse when one party doesn't act in accordance with their responsibilities and obligations. So this could be withholding payments, mediation and arbitration, or other legal proceedings. There are many functions of shared agreements. One function is easements, including granting access and rights of use, easements for construction, maintenance, and repair, or easements granted to a developer for the purpose of continued construction. Then we have cost sharing of shared assets, utilities, and property. The agreement should define and set out the costs to be shared and how they are to be shared. The proportions for each party can be calculated in a number of different ways, and this will be set out in the agreement, we hope, such as square footage, number of units, etc. Sometimes it's fair, sometimes it's not. Another function is governance of the shared facilities, the shared assets, shared services, and shared property. So this could mean the creation of a shared committee with representatives from each party and a voting system to make decisions. It could also mean one party is responsible for making decisions and reporting to the other parties. It really depends on the unique relationship between the parties and what makes most sense. Part of this is also management. So sometimes there's a shared property manager, or the same management company will be engaged by each of the parties. So in an ideal world, the written agreement is clear and articulate. Each party understands their roles and responsibilities and carries out the same without any argument and in a timely manner. In reality, things are a lot more messy. Agreements are old and outdated. They're not clearly drafted. They lack clarity in defining the components that are to be shared between the parties. And of course, there are always disagreements about money. Is the proportionate share to be paid by the parties fair? Is it based on logic? What if one party uses an asset more than the other, but are supposed to share the cost equally? Sometimes it's more simple. The parties just don't like each other and don't want to cooperate, making everything a fight. So generally, these agreements look good on paper, but when the parties start to use the shared facilities, that's when the issues emerge. So next slide, please, Justine. Okay, Anatomy 101. So we've created a metaphor for how to look at shared agreements based on human anatomy. I'm just going to give a brief overview, and then we're going to get more in depth into each of the parts as we go through this presentation. So first is the bones. The bones are the skeleton or the basic makeup of the structure. In this case, the bones are the parties and the property that make up the shared. There's no agreement without the bones. Next is the heart. If the bones are the structure of the body, the heart is the core. Its job is to pump blood throughout the system to keep everything functioning. So in the case of shared agreements, this would include the shared facilities, assets, services, servicing systems, and any easements, which are at the center of the agreement. So basically, what is being shared? The arteries and the veins pump blood to the heart and keep the body and the heart working. For shared agreements, this includes the cost of maintaining, repairing, and operating everything that is shared. The brain, this is where all the decisions are made. So in this scenario, the brain would be the shared facilities committee or whichever parties are authorized to make decisions on behalf of the shared. And finally, the systems. In the body, the parts of each system work together to perform different jobs. In this context, the systems are major capital repairs and replacements, shared facilities budgets, shared accounts, and shared management. Next slide, please. So the bones. The first important part of anatomy is the bones. Again, these make up the skeleton, which serves as the framework for the body. So there are two components to consider here, the parties involved and the properties involved. So the parties could be developers, condominiums, both residential and commercial, residential apartment buildings, or commercial entities. The relationship between these parties can be simple, so for example, just two residential condos, or more complex, such as a developer, a residential condo, and a commercial entity such as a hotel. Things become more difficult when a condo is party to a shared agreement with a freehold component that isn't subject to the same rules and fee-based systems as a condo, such as reserve fund contributions, which can make cost-sharing arrangements more sophisticated. These relationships can also change over time. For condos, the relationship usually begins with one or more developer, and then once the condo is complete and registered, an assumption agreement will be executed, which transfers the obligations and responsibilities to the condo. So the second component is the properties. Same as the parties, there could be a mix of residential or commercial condos, residential buildings, commercial entities, or land that hasn't been developed yet. The properties are also not limited to just the buildings. There are landscaped areas, roadways, parking lots, outdoor amenities such as tennis courts and swimming pools. And then within that, there are individual components of each that are shared, which Ashley is going to talk about in a little bit. So the question is really whether the design matches the expectations of the parties. In reality, these agreements rarely work out as they're intended to. So that's always interesting. I'm going to pass it over to Ashley now to take us through the rest of the body part.
Hi, Justine. Next slide, please. Hi, everyone. I'm going to be going through the remaining components of the anatomy of a shared agreement, and I'll be starting with the heart. So the heart consists of the shared facilities, assets, services, and shared servicing systems and easements. All of these can be compartmentalized, and sometimes there's a bit of confusion as to are they the same thing and how do they overlap with one another. So shared facilities are generally defined as the parcels of land, so perhaps a common roadway, the facilities like a clubhouse or pool, any service units and facilities that are shared by the parties to the agreement. Sometimes the facilities are shared by all of the parties, or some are shared by a certain number of parties, and it's broken down into categories. The definition of a shared facilities is usually quite broad and is sort of a catch-all definition at times that can include shared assets, shared services, and shared servicing systems, which I'll be discussing. So the difference between shared facilities and shared assets is that assets refers to the capital assets, the equipment and the chattels that are used in connection with the shared facilities or with maintaining them. So this could include, a pool if that's part of the shared facilities, and even a snow plow. Some corporations, they have their own snow plows if there's a shared roadway. And we generally recommend that the assets in any shared agreement be specifically listed and incorporated in a schedule to the agreement. A lot of the old agreements will not define the shared assets in this manner, but it's really helpful to do so, especially when you're starting to look at repair and maintenance obligations and reserve fund studies. Shared services are the services provided in relation to the shared facilities and shared assets. So this would be any property management services that are provided to the parties collectively, utilities, as well as cleaning services, landscaping, anything like that. In shared servicing systems, they differ from shared services because that refers to the actual components that comprise the mechanical and electrical systems that serve the property belonging to two or more parties to the agreement. These generally include storm and sanitary systems, emergency lighting systems, fire protection systems, and the definition is generally drafted so that it excludes any systems that exclusively service one of the parties. Easements and rights of way are generally the parcels of land that the parties to the agreement will have a right in the nature of an easement to use and enjoy in the instance of a clubhouse or a pool or a tennis court that's shared. Or there could also be a right of way for the purposes of vehicular and pedestrian ingress and egress. And there's, as Julia mentioned at the beginning of the presentation, other easements and rights of way can be provided for repair and maintenance, structure, support, and construction. So in order to find out where these easements are situated and what rights are granted, it's important to look not only in the agreement itself, the shared agreement, but also in the parties, if it's all condominium corporations, their legal descriptions as set out in their declaration, as well as any other agreements registered on title or any other instruments, because sometimes there are separate easement documents registered on title. Next slide, please. So arteries and veins. I spoke about the heart, and the arteries and veins in this particular, excuse me, sorry, if you could, thank you. This particular scenario refers to money. It's the blood that makes everything work. And shared costs and cost sharing obviously are very related to one another. So shared costs are the costs that are shared by the parties to the agreement in accordance with their proportionate shares. And the proportionate shares are the percentage of shared costs that each party has to pay. So in a typical agreement, there's an all-encompassing definition of shared costs. And this is generally, these costs are generally divided amongst the parties in accordance with the standard cost sharing formula. And as Julia mentioned, this cost sharing formula can be based upon a number of variables. However, we generally see that it's based upon the number of units at each party relative to the total number of units at all of the parties to the agreement. However, the proportions can also be based upon other variables such as use or consumption, particularly with respect to utility costs. And in that particular instance, it's important to ensure that the manner in which the costs are proportioned is based upon a verifiable calculation that has been verified by someone with the required expertise, like a mechanical engineer, and that particular formula being relied upon be included in the agreement. In more complicated agreements, or in agreements where there are more than 2 corporations, or where there are a variety of different shared facilities, we generally see a general definition of shared facilities, and then more specific cost groupings or categories. And the cost grouping and categories can be utilized because some facilities may only be shared by 2 of the corporations. Others may be shared by all 4. So for each of the specific cost categories, there would be a specific calculation or formula indicating how those specific costs are to be shared. And in those more complicated agreements, the issues tend to arise when sort of reconciling, okay, if there are all these different proportions, which could make sense, if if a party doesn't use an asset, it doesn't make sense for them to have to pay costs towards it. However, it is a bit difficult when you're reconciling all of those costs in order to just determine what each party needs to contribute when you're preparing the budget and looking at the reserve fund. But it is possible, and sometimes parties find that it's the quote unquote fairest thing to do. In terms of utilities, utilities that are shared form part of shared costs. And as I mentioned, they can be proportioned based upon submeters, the costs, or by a formula prepared by generally an engineer. Sometimes installing submeters or check meters can be expensive. So corporations want to go with the calculations prepared by an engineer, but it's important that there be something in place to understand how much of the utilities the corporations are required to share in each party's respective portion. If you could turn to the next slide, please. The Shared Facilities Committee. Shared Facilities Committee is the brain of the entire operation. And I'm going to be talking about shared facility committees in terms of their composition and governance in agreements that are quote unquote fair and healthy. So shared facility committees, a lot of the times there's a misconception that they're separate legal entities, and they're not, unless they're actually a registered corporation, which we have seen, but the majority of the time they are not separate legal entities. So bank accounts cannot be held in the name of the committee, and the contracts cannot be executed in the name of the committee. Any contracts and all accounts have to be held and done jointly in the name of the corporations that are parties to the underlying agreement. So in terms of representation, generally each party to a shared agreement will have the ability to appoint one or the same number as all the other parties representatives to serve on the committee. Generally, the representatives have to be board members or unit owners of the corporation that they are appointed by. But a lot of the time, the shared agreements are silent. So it's important that you look at your shared agreement to ensure that whomever is sitting on your shared committee does in fact have the necessary qualifications to do so. In the vast majority of scenarios, representation on the committee does not necessarily reflect how costs are shared between the parties. However, it can. Sometimes the representation does reflect how costs are shared. So if there's two corporations, one pays 60% and one pays 40%, the corporation that pays 60% may have more members on the committee than the party that pays 20%. Now, in terms of voting, so each member appointed by a party to the agreement might have one vote, or the members appointed by a single corporation may have to decide how to cast their single vote on behalf of their corporation. And in terms of how many votes each party or member gets, it's not going to necessarily reflect how costs are shared. It just depends on how the agreement has been drafted and if the parties are considering amending the agreement, how the parties have mutually agreed to grant each other voting rights and how they mutually agree to govern the shared committee. So we have seen many agreements particularly those drafted by developers, where the corporation is entitled to have a representative on the committee, but the representative has no voting rights, and the voting rights are held by the members appointed by the developer, even though the costs are paid entirely by the condominium corporation. And we've seen many agreements like that. And it's important that if you're a new condo, that you touch base with your corporation solicitor to ensure that any shared agreement that you're a party to is carefully reviewed within the first 12 months. And I'll get into that a little later on. In terms of authority, your shared facilities agreement should state what authority the committee has. What can the committee do? Generally, the committee can make decisions on operation, repair and maintenance, services, work to be conducted, preparing budgets. However, sometimes there's also restrictions on authority. So in your agreement and in your corporation's governing documents, does each member of the committee need to obtain the prior approval of their board that they're representing? Or are the boards bound to the decisions of the committee? And aside from just any restrictions that might be contained in the documents themselves, the committee has to still comply with the Condominium Act. So the committee, the representatives of each corporation, they can't do anything that would constitute a change in either the assets or services provided without complying with Section 97 of the Condominium Act. And there can be no change made to easements or rights of way without complying with Section 56 of the Condominium Act with respect to easements and rights of way. In terms of voting thresholds, the vast majority of shared facilities agreements I've seen stipulate that the decisions of the committee must be unanimous. However, there's also some where they state that the decisions of the committee might be just by majority or supermajority. I don't see a lot of agreements that contain supermajority. It's generally majority or a unanimous decision. And this, of course, as I'm sure many of you who have attended this webinar today may have been engaged in, can create disputes. Often there's a deadlock. If there's two condominium corporations, they have two different interests, particularly, let's say the road needs to be repaired, and one corporation wants to spend the money to do it, the other corporation doesn't, and they're at a deadlock and they're not moving forward and getting the work done because they can't come to a decision. So in this particular event, you have to look to your agreement to see, okay, does the chair of the meeting have a deciding vote? Can they cast a vote in the event of a tie? If not, look to the ADR section of your agreement to see if the corporations are required to have a joint meeting of the boards. Generally, that's required, and it is advised and it's also advised that it occurs as soon as possible, because that can ensure that a minor dispute doesn't escalate and result in excessive costs being incurred by all the parties and the asset deteriorating further. The next slide that I'll be discussing are the systems. So I spoke about major capital repairs and replacements, and usually when they need to be done, this is the source of a dispute. Yeah, a lot of the time, corporations, although they share facilities, they may have different priorities in terms of how they want to spend their corporation's resources. So the assets that form part of the shared facilities, they have to be, a reserve fund study has to be conducted for them. So in this regard, if all of the facilities and assets are situated on one condominium corporation's property, the committee and that corporation have to decide whether those components and assets are going to be included in that condominium corporation's reserve fund study, or if there's going to be a separate reserve fund study done for those components. So if the committee decides to go with the latter and have those components included in the corporation's reserve fund study without any separation, the parties then have to determine how to isolate the costs that are recommended contributions in terms of those facilities. Oftentimes we have seen that the shared facilities are situated on a parcel of land that is potentially owned by all the corporations as tenants in common. In this scenario, it's much more simple. The corporations would be required to do a reserve fund study for those assets, and there'd be no issues in terms of isolating which components form part of the shared and which components serve only one corporation. Shared facility budgets. This again is where a lot of disputes arise, and some corporations, they want to push that major repair replacement and in a particular fiscal year, where the other corporation might not want to do so. They don't think it's a priority, or they don't have the resources. So look to your agreement to see how the budget is to be prepared and approved. Your agreement might stipulate that the corporations have to approve the budget prior to coming into effect, or it might say that the corporations are bound to the budget prepared by the committee. In terms of shared accounts, as I mentioned, the shared committee is not a separate legal entity. So any shared accounts have to be held jointly in the names of the legal entities that are the parties to the agreement. So there should be a shared operating account and a shared reserve fund account. Sometimes corporations are hesitant to have a shared reserve fund account because they feel as though it's a significant chunk of change and they want to have sole control over it, or they don't. There's some trust issues there. So in that particular situation, some corporations decide to have a sort of separate reserve fund account in their name only, or they can incorporate it as their general reserve fund account. And then they make contributions based upon the funding plan that the corporations and the committee have passed for the shared committee. When that is done, however, the agreement should incorporate mechanisms that allow the corporations annually or upon request to verify and confirm that each party is in fact contributing to the quote unquote reserve fund in accordance with the funding plan. Because we see disputes generally arise when there's not enough money there and something urgently has to be done. And then the facilities are closed, owners get mad, and then we get a bunch of calls for our assistance. It's better to take proactive action and try and save and reach out to the proper professionals prior to that dispute escalating. Shared managers. The agreement might stipulate that the manager has to be an independent, and might stipulate that the manager has to be a manager of one of the corporations. Oftentimes we see disputes when the one party feels as though the manager, who represents another corporation as well, is sort of favoring the interests of that corporation. So in that particular instance, in order to improve the working relationship between the parties, it might be the best alternative to amend the agreement to provide that the manager rotates on an annual basis, or that the manager has to be entirely independent from the two corporations. This time, I'm going to turn it over to Patricia, who's going to talk about disease prevention. Or excuse me, yeah, the unfairness in disease prevention.
We'll get to disease prevention. Thanks, Ashley. So if we could have the next slide, please. So let's start with a healthy agreement, what it looks like. We've had a pretty good overview of all the systems and the parts that go into a good agreement. And generally, we need to think about what is our expectation when we see a shared facilities agreement on the horizon, whether we're the manager or board of directors or a new purchaser. We need to think about what components go into a really good agreement. First, it should be fair. And that you really have to look at the intention of the agreement. Is the intention fairness? Because you get drawn into an agreement created by a developer, it's disclosed to you, and it doesn't necessarily have to be based on fairness. Okay, so that's one of the key things. But most people assume it will be fair, that it will be transparent, which means that you can understand how everything works clearly when you're sitting as a committee member or you're observing as a unit owner that ends up paying the costs associated with shared. That it's comprehensive, that nothing has been left out. We've seen shared facilities agreements where there have been component inventory assets that have not been addressed, such as cooling towers. And the interesting debate there is, well, it would be fair if you paid for this asset, but the position is often, but it's not in the agreement for us to pay for it. So therefore, we're bound by what the developer put in place for us. And this is where evolution and time helps us understand better what should be in the agreement. We should also be consistent with our governing documents. Ashley has referred to compliance with the Act. Section 97 still can't be in any way overridden because the reality is somebody owns these assets. Now, often the parties in an agreement are all condominiums, residential, commercial, but sometimes they are not condominiums. And that brings up another set of interesting parameters. What if they're private entities? What if they're controlled by the developer? And they're not bound by the Condominium Act. But the issue will always be that assets of a corporation, a condominium corporation, are being impacted through the shared agreement. And therefore, compliance with the Condominium Act should be at the forefront, together with compliance with constating documents. In terms of developer involvement, this is really hard to negotiate because developers write the agreement that you inherit. If they control the entities that control the parking garage, that control the commercial space at the bottom of the condo, it is going to be dealing with the developer, but not necessarily as a developer, but as an ongoing commercial entity. And so it needs to be really thought through what the implications are. Fortunately, there is case law that says your disclosure packages really need to tell you what the risks or the implications are of using or of these agreements, of the results of these agreements. We've seen certain circumstances where the actual development didn't go the way it was planned. And now it has created this real imbalance in the roles of the parties. Parties that do not pay, for example, a significant portion of the cost are the ones that are controlling decision-making. That to me, just having experienced it, it doesn't make any sense. So it's also that it's got to be easy to read. I've read some agreements that are beautifully drafted from a lawyer's perspective, fantastic, and they deserve the highest level of legal writing because they're complex. But people need to be able to actually absorb them, understand them. We have some very complex shared facilities agreements in our portfolio of clients, And they go on for pages and pages with respect to the easements alone. And I can appreciate from a shared facilities manager's point of view, really being able to understand and get on top of all of these components to understand what the boundaries are that are trying to be set. And that's, to me, where we go and look to try and create a healthy set of agreements. But what happens when it's not healthy? So if we could go to the next slide. When we have disease, it means that the overall body or systems within the body are not well. And unfortunately, in condominiums, this takes the form of, often at the heart of it, the root of it is unfairness or perceived unfairness. And that relates to a bunch of other issues. There are all these dots that start to happen. So when we look at it, often people see unfairness in decision-making power. Ashley alluded to how decisions are made. I just spoke about an example where people who are paying less than 10% are controlling the actual committee's decisions and how they're made, which is creating a huge amount of disruption. And that's what we need to think about is where is this unfairness? Is it truly unfairness? And how can it be remedied? Often there are arbitration clauses in place, and the Act requires that we go to mediation and arbitration to resolve disputes. The courts are supporting that position more and more in condominium related matters. And so we need to make sure that we also as condominiums have good mediation and arbitration bylaws in place. So when we're dysfunctional, voting also becomes an issue because, again, how are decisions being made? Who has control? We've actually designed systems where certain members will get the right to vote in different proportions because the decision impacts them differently. And these are decisions that have huge cost components associated with them with respect to capital assets, not just operational decisions. So now what we need to start doing is thinking about how decisions can be cross-sectioned. It's not always going to be one body, one vote. It could be you're entitled to 10% of the vote, or you're entitled to exercise a portion based on the topic we're talking about. Are we talking about HVAC as assets or systems? Are we talking about elevator systems where you use more of the elevator than other parties? So it's important because it does implicate and have an effect on the end cost to the users. Then as well, are shared costs adequate? Are they comprehensive, first of all? And Julia had alluded to that. Have we covered everything? And are we doing it correctly? This is where technical experts are usually the best people to make the decision. I'm just a lawyer. I can't tell you how much you're using of an asset, especially when it's something like a roadway. That's where engineering is very advantageous to corporations. And these days, engineers are writing reports where they actually give you different ways at looking at use. Could be consumption, could be square footage, could be number of doors. But number of doors is not always the most logical way to go, depending on who's in the asset group and how the assets are broken down. So that's the great thing that engineers can do. They can bridge the logic and help parties decide. As well, committee representation, as we've talked about, this goes to decision making. Who should be there? Who should have a vote? Do you have to have a technical consultant? What kind of evidence needs to be before the committee before they make a vote or make a decision? Developer involvement, that can be complicated. It can be a conflict of interest. Because here's the thing, when you're early on, what happens if you find out that there was actually a construction deficiency in one of the assets that is shared? And it's up to one of the condominiums through, let's say, their Tarian protocols to make sure that the claim is made. You know, should a declarant be at the table where the shared facilities committee is making these decisions? My position would be no, because you're on the other side. And that's what we are not necessarily always looking at. We're not looking at where the conflicts of interest lie And is there a clear definition of what the conflict is? And sometimes transparency of the conflict is not enough. It needs to be that no decision-making power should be exercised. Financial contribution is always really important to make sure it's fair because of affordability. Ownership of assets, this is where really taking the time with your lawyer to understand what is within your bailiwick. For occupier liability purposes, you know that the condominium is going to be responsible for all the common elements that fall within the definition of its common elements, boundaries, assets as well. And so you need, under a shared facilities agreement, if you're the condo that owns the asset, the right to respond to be able to manage risk, because the buck will stop with the condo. A shared facilities committee is not a legal entity. If you're going to get sued, everybody's going to get sued. So in managing the symptoms of, ownership that are associated with, how do I control my property? You need to also make sure the mechanisms are in place that if, for example, the condominium who's responsible for an asset sees that the walkways, which are shared assets, are not being properly maintained at the shared facilities committee level because the developer says, who controls the committee says, yeah, no, it's not important. You as a condo still need to do the work, and then you need to put the committee on notice. And there should be a mechanism that if you undertake work on behalf of shared, that you can send the bills back right to the committee and the committee will be obliged to pay. And then the question is, how do you get the money? So there are these other issues that you can see blow up into other things. And you as managers, those of you who are managers, know that this is where it gets muddy. As well, it gets muddy for management in trying to understand who do they work for. If shared is not an entity, Patricia, who is signing the agreement? Well, all the parties need to be signing the agreement, which means it makes it complicated because you're listening to everybody and arguably they're each and individually your client. So how do we mesh this? What we've done is we've created scopes of authority for the shared manager. So you can get out of the muck and make sure that the management agreement parallels the requirements under the shared facilities agreement. That is the way that, we connect the dots to actually minimize these symptoms, minimize the disease that comes associated with unfairness, perceptions of unfairness, and lack of trust, because really what's underlying this is a lack of trust. Effective dispute resolution mechanisms are really, really key here, because if you don't have a good system to say, you know what, we're going to take your concern about this budget line item. You think it's too much. Okay, we can understand that maybe you think that spending $100,000 on flowers for shared is a waste of money. What you don't want to happen is that the whole budget gets stopped on a dime because of flowers. Okay, I've had my experience with cases dealing with flowers and they can get out of control. So what do you want? You want to think about how do we minimize the risk so we can all contribute, have cash flow, keep the actual system, the body functioning. And that's where a good dispute resolution mechanism, which will be, all right, you want to go to mediation? Let's go. We can do that. Put us on notice. If we can't mediate it, let's go to arbitration. Okay. Maybe we need a technical consultant to trigger our right to do both of these things. And it could also be that you need to show us that there is a material difference. You're saying 100,000 is too much, but 99,000 is good enough. We usually put in percentage mechanisms to help us limit the amount of dispute. To say you can't go to dispute if it's not more than 10% of a difference in the bottom line. And these kind of mechanisms, which are a little bit more detailed, more refined, are the kind of attention to detail that you need in your operating systems to make things flow so that you can keep operating. Because what you don't want to do is have somebody say, yeah, not approving the budget, not paying the budget. Good luck to you all, right? Because then you're picking up the slack because suppliers still have to be paid. And then you get into litigation. So If we could go to the next slide, please. So we are predisposed to certain health risks. And, one of the key things is the lack of legislative guidance. We go to mediation and arbitration. Every agreement is deemed to have this provision. But, I know that Bob Gardner and I years ago in I think 2015, drafted general parameters on what should be in a shared facilities agreement. We sat down and we said, these are all the anatomy pieces that should be in an agreement. So right now with the government, through the ACMO CCI legislative process and even the reformation to the Condo Act, there are sections we understand that are going to be coming maybe through regulation that will deal with content. So, but right now we have a lack of real clear definitive parameters. These agreements are often drafted prior to registration, so we're kind of stuck with them. There are options to deal with them. I think Ashley's going to touch on those a little bit later. But, when they're drafted by developers, and not all of them are poorly drafted, but we have seen some that are poorly drafted, or they're drafted intentionally to serve developer interests. They lack practical solutions and common sense kind of components that work with the practical realities of the assets. And the draft, like I said, the drafting doesn't reflect reality, or they're incomplete. So really, when you get onto a board and it's a new condo and you got shared agreements, you should take the time to work with council to say, hey, is this a good agreement or is this going to be a problem? Also, dealing with management, say, hey, does this agreement work or does it not? Is it unfairly prejudicial? Next slide, please. So I'm going to pass it back over to Ashley.
Disease prevention. So the most important thing I would recommend in terms of preventing conflict at the onset is reach out to your corporation solicitor and obtain a legal opinion. Have them review the shared agreement in addition to any other relevant instruments. They'll be able to determine what's relevant to provide the corporation with an opinion that enables the corporation to understand, what their rights are, what their obligations are under the shared agreement, and how various components of the shared agreement affect their corporation or will affect their corporation. These agreements, as Patricia drafted, some are very well drafted. As Patricia mentioned, some are very well drafted, but in terms of trying to find out and understand what parcels of land specifically form part of the shared facilities or are subject to an easement can be difficult. Often plans are referred to, which requires a law office pull the plans, and they're not something that typically the regular individual would be able to ascertain. They're quite detailed. So that's what I would recommend. We've prepared opinions for many of our clients, and some of them we've highlighted to the corporation that they own certain parcels of land, which they are surprised about. They didn't even know that they owned that land. They thought it was owned by the other party. We've also prepared opinions where we've highlighted what's supposed to be a shared cost, and the corporations stand back and they're like, wait, we could have been charging back a particular proportion for X number of years. Wish we had known this sooner. So that's my number one tip in terms of disease prevention. And this is particularly important if you have a new condominium. Condominiums that have been registered within the last 12 months, or any condominium provided that they're brand new, can apply under Section 113 of the Condominium Act to have any shared agreement that they are party to amended or rescinded by court order. However, in order for that to be done, the application has to be filed within 12 months of the corporation's turnover meeting. There has to be an inadequate disclosure of the provisions of the agreement in the disclosure package that would have been provided to purchasers. And the agreement must produce a result that is oppressive or prejudicial to the corporation bringing the application. And if your corporation is not a new corporation, it might be advantageous to inquire with the other corporations that are parties to the agreement about amending the agreement. As Patricia mentioned, we have incorporated a lot of out-of-the-box practical tools in the agreements that we have drafted that enable the corporations, in the event of a deadlock, to continue to operate their facilities and continue to ensure that contributions are being made, even if the corporations can't agree on a budget or a particular repair or maintenance matter. If you could turn to the next slide, please. So treatment. So this is in the event of an existing dispute or a pending dispute. Look to your ADR, alternative dispute resolution sections in your agreement. They will likely require that a joint meeting of the boards be held. If the matter is not resolved, that the matter then proceed to mediation, followed by arbitration. Corporations should not be afraid about asking for a joint meeting to be held or going to mediation. All good working relationships are going to have disputes, and good working relationships acknowledge that and proactively at the onset take the steps necessary to ensure that those disputes are resolved. So the joint meeting with the boards, with council present, is a great tool, and at those meetings, some of the miscommunication can often be resolved, and the parties can collectively agree upon practical steps to move forward in order to avoid, the dispute escalating further and each corporation incurring further legal expenses. And as I mentioned, at that agreement, the corporations may decide to amend the agreement. That's often the best alternative because these agreements often do not reflect the practical reality of how the corporations interact with one another. If you could turn to the next slide, please. So key takeaways for you to walk away with. Number one, exercise regularity, meaning that go to your corporation solicitor, get that opinion, ensure that you understand your shared facility agreement, that you understand how it affects your condominium. And that's particularly important if your corporation has just been registered within the last 12 months. Take charge of your own health and be your own advocate. In this particular scenario, it means when your shared facility members attend the shared meetings, speak up. Ensure that any opposition is noted in the minutes. And if you have a question regarding any costs that your corporation is being asked to contribute towards, request the backup documentation to verify the costs. Ask for specifics. Know the warning signs of disease that Patricia mentioned.
Hi, Ash. We're running out of time, so I'm going to have to ask you to finish up right now so I can get to Julia.
Okay, I will. Essentially, don't be afraid of treatment, and early intervention is the key.
Great. Thanks. Julia, you have one case to leave us with because I note that we have some questions in the Q&A that we're going to answer. So why don't you take us through this case?
Okay, so the case is SVLCC 272 versus Blue Shores Development. The Ontario Superior Court decided this in 2014, and it was affirmed by the Court of Appeal in 2015. So the dispute in this case related to the ownership and control of a clubhouse, which the developer had owned and operated from the outset. There were 4 condos that brought an application claiming breach of trust and oppression against the developer, seeking a declaration of ownership of the clubhouse, a declaration that a mortgage that had been registered on title to the clubhouse was void, and an accounting of all monies that had been collected as membership fees for the clubhouse. The Superior Court dismissed the application and the Court of Appeal affirmed that decision. So the disclosure statements that the developer gave to the purchasers of the condo units had confirmed that the clubhouse would be conveyed to the condos within 120 days after the date the developer no longer owned any land. There was also an easement and cost sharing agreement between the condos and the developer that said as long as the developer owned and operated the clubhouse, each unit owner was required to pay a monthly clubhouse membership fee. So the first issue was ownership and conveyance. The developer had not yet sold all of the vacant units or the land within the project, which meant the conveyance obligation in the disclosure statement hadn't been triggered yet, and the developer still owned the clubhouse. So the court said that the condos had misinterpreted the contractual obligations. The developer's obligation to convey title to the clubhouse in the future was not an executory contract that had already received consideration. So this means the disclosure statements did not constitute a contract between the developer and the condos, and the condos didn't have an equitable interest in the clubhouse and no rights capable of registration under the Land Titles Act. The court also said the clubhouse had been intentionally excluded from the governing documents and expressly indicated that an interest in the clubhouse was not being conveyed with the sale of each condo unit and was therefore not included in the common elements conveyed to the purchasers. There was also an issue with a mortgage that the developer had granted and registered on title. The court said the developer was not a trustee of the clubhouse, but was an owner, and there was no prohibition in any of the documentation against them obtaining and registering a mortgage, and said that this was fine. There was also an issue with respect to oppression. The condos said that the developer had acted oppressively in failing to convey the clubhouse. The court basically said that the